Hello, good evening, everyone. Welcome to the YouTube channel of RankersBuzz. Today we are again here with a new judgments. Today we'll discuss about the landmark judgments of the year 2022-23. So let's begin with the today's session. In the today's session, we are going to deal with the judgment, which is actually dealing with the Article 12 of the Indian Constitution. So if we see this Article 21, we all know that this is part of the fundamental rights fundamental rights that is situated in the part 3 of the Indian Constitution. And we all know that when it comes to part 3, it is all about the fundamental rights, and Article 12 to 35 lies in the fundamental rights. And we all know that when it comes to the fundamental rights and the cases related to the fundamental rights, they are always filed against the state. Whenever there is a violation of any fundamental right, and certain writ petitions are filed, like we have 5 writ petitions with us. So whenever writ petitions are filed, they are always filed against the state. And here the state has different meanings. It can be central government, it can be it can be central government, it can be state government, or any other government organization. But where does this state defined in the Indian Constitution? अगर हम देखें तो आर्टिकल 12 क्या कहता है? क्या ये स्टेट को डिफाइन करता है या फिर स्टेट को कुछ और डिफाइन करता है? व्हाट डू वी अंडरस्टैंड बाय दिस टर्म स्टेट? स्टेट के अंदर क्या क्या आ सकता है? क्या ये सिर्फ भारत सरकार है, या सिर्फ ये भारत सरकार और राज्य सरकार है, या फिर ये पार्लियामेंट भी है, ये लेजिस्लेटिव असेंबली भी है, ये जुडिशरी भी है? आखिर ये स्टेट के डोमेन के अंदर क्या क्या चीजें आएंगी? That we have to see, and today the judgment we are going to study here will also be dealing with the same question, that whether a particular organization will come under the definition of state or not, and if it comes under the state, then can we file writ petition against them? So this is, so we already know that if some organization is a state, then definitely these 5 writs can be used against that organization. तब तो हम use कर ही सकते हैं if that is a state. So first, let's see what is there in the Article 12. What does actually Article 12 talks about? So if I can tell you, the Article 12 basically is the talks about the definition of state. It actually tells you that what do we understand by a state and how a state can be defined. So let's see what exactly written in the Article 12 here. So if we see the Article 12, then it has been mentioned here. If we just look at this, it says that when it comes to Article 12, this definition, this part, unless the context otherwise requires, the state includes, बताता है state क्या क्या include करता है. First thing, the government and the Parliament of India, the government of India, the first one, and the Parliament of India. Third one is the government and legislature of each of the state. That means the government of a state, and the legislative assembly or legislative council of a state. They all will be under the definition of state, and all local and other authorities within the territory of India or under the control of government of India. या फिर जो भी local authorities हैं, all the local authorities. So this is the third one, this is the fourth one, then we have the fifth one, that is the local authorities. For example, local authorities की अगर हम बात करें, then what can be the different local authorities? Like we have the Panchayati Raj system. पंचायती राज के अंदर जितने भी हमारे इंस्टीट्यूशंस आते हैं, then we have the municipalities. Again, they are also part of the government. So municipal corporations will again be come under the local authorities, but it does not end here. Lastly, it says under the control of government of India, या फिर वो organization जो इन सबके control में आती है, either it is the central government or it is the parliament, or it is the the state government or the local authorities, इनके अंडर में जो directly आते हैं organizations, they all will consider to be a state. For example, if there are multiple organizations run by the government or with the support of the government, like for example we have many PSUs, public sector enterprises, like we have the uh, you know GAIL, then we have the BHEL, also have NTPC, NHPC, all such organizations which are supported or funded by the government. They are all said to be the state. वो कहाँ cover होगी? They will be covered under the definition of state. ये सभी जो हैं वो state की definition में cover होते हुए दिखाई देंगे. Now, many a times this question has raised whether this organization, some X organization, Y organization, or Z organization, whether they come under the definition of state or not. Such questions has been, asked again and again, and it has also been answered by different, judicators of High Court as well as the Supreme Court in different cases. And there is a specific question with respect to the educational institutions also, whether the education institution will fall under the definition of the state or not. Whether, then again, if it is so, then what about the public and the private education institutions? Whether a public institution or a private institution will fall under the definition of state? क्या सिर्फ public आएगा या फिर private आएगा या फिर दोनों आएंगे? So this question has also been asked again and again, and in multiple judgments, the Supreme Court has said that when it comes to, especially to the educational institutions, then either it is public or private, they will be considered state when it comes to the, you know, filing a writ petition. With respect to the fundamental rights, definitely it will also be considered to be a state, even though it is not, fully supported by or partially supported by the either the state government or the central government. Even then, they will be called as the state, for especially for the fundamental right, violations. So this is how we understand state. इस तरीके से हम समझते हैं कि state आखिर होता क्या है. This is how it has been mentioned in Article 12. And so today's judgment is related to that only. We will discuss upon that, what exactly that judgment talks about. So just coming to that judgment. So the today's judgment is the Kishore Madhukar Pinglikar versus Automotive Research Association of India 2022. So when it comes to this particular judgment, definitely the question which arises in this judgment is with respect to the state, whether this particular organization falls within the ambit of a state or not. क्या हम ऑटोमेटिव रिसर्च एसोसिएशन ऑफ इंडिया को स्टेट बोल सकते हैं या फिर स्टेट नहीं बोल सकते हैं? दिस क्वेश्चन वाज एक्चुअली रेज्ड इन दिस पर्टिकुलर केस. अब now, what is this Automotive Research Association? Actually, it's a research and development, or we can say an R&D organization, which is actually engaged in, doing research and development with respect to the automation. जो automotive है, auto sector है, उसको लेके जो है ये जो organization है, ये research and development करता है. And it is engaged in that only, and it is not been supported by in any ways by the government. So now let's see what exactly happened in this judgment and who was hearing this judgment. So it was a division bench decision given by Justice Sanjeev Khanna and Justice Bela M. Trivedi. These were the two judges who were there in the, when this judgment were pronounced. These were the two judges in the division bench. So now coming to the questions being raised in this question, कि क्या-क्या चीजें हैं जो यहाँ पे raise की गई. So the first thing is that the niche question that arose in this matter was whether the respondent Automotive Research Association of India is a state within the meaning of Article 12 of the Constitution of India and residently covered under Part 3 rights. So the the first question which has been raised here is whether this particular association, that is Automotive Research Association of India, whether it is a state or not within the meaning of Article 12. जो Article 12 कहता है स्टेट के बारे में, क्या ये उसके अंदर फॉल करता है या नहीं फॉल करता है? This is the very first question. And if it is, if it is falling or not falling under Article 12, whether that result will cover it under part 3 of the constitution, which talks about the fundamental right. क्या फंडामेंटल राइट्स वायलेशन होता है, या फिर उसको लेके क्या रिट पिटीशन इस पर्टिकुलर ऑर्गेनाइजेशन के खिलाफ फाइल की जा सकती है या नहीं की जा सकती है। और अगर मान लीजिए यहाँ पे होता कि स्टेट नहीं है, तो डेफिनेटली there is an answer to it, that no such petition can be filed, especially the writ petition, when it is not a state. So yes, this was the first question which is being raised. Next, it says the court called out the governing parameters and test for determining whether a body falls within the purview of Article 12 on the basis of long line precedent, including the Constitution Bench judgment of Pradeep Kumar Biswas versus Indian Institute of Chemical Technology. तो अब कोर्ट यहाँ पे कहता है दैट वी विल डिटरमाइन डिपेंडिंग अपॉन द डिफरेंट टेस्ट व्हिच इज ऑलरेडी बीन अवेलेबल एंड गवर्निंग पैरामीटर्स, जो कि हमने लास्ट इन मेनी इयर्स वी हैव प्रोनाउंस्ड इन डिफरेंट जजमेंट, अलग अलग जजमेंट्स में हमने पहले भी डिसाइड किया है. एंड अमंग दैट वन इज द प्रदीप कुमार विश्वास, अ वेरी लैंडमार्क जजमेंट ऑफ 7 judge, it was a 7 judge bench decision which was given by the Supreme Court with respect to the definition of state in this particular judgment, that is Pradeep Kumar Vishwas versus Indian Institute of Chemical Biology. So in this, it was held that ki bhai, Indian Institute of Chemical Biology was part of the ICRI. We all know that ICRI is a government body which has been formed by the government, funded by the government. Appointments are done by the central government, and also the Prime Minister is the ex officio president of this ICRI, or we can say the ICMR. So when the president himself is the ex officio president of such an organization, and it has been even funded by the central government, then definitely it will come under the definition of state. तो फिर तो ये स्टेट की डेफिनेशन में आएगी, ऐसा कहा गया था प्रदीप कुमार विश्वास के केस में, where it was funded as well as controlled by the government. But now we have to see what is the present condition in this particular judgment, that is Kishore Madhukar Pinglekar. Because here we are talking about the Automotive Research Association of India, which is not exactly run by government, and it has its own rule and regulation to determine its fate. So let's see what exactly has been said here. So it says that it was found that government never had any say in the constitution, establishment, or operation of the Automotive Association. So here it was found that when it comes to the Automotive Research Association, then when it was, actually established or constituted, or during its operation, the government has no say. जो either the central government or the state government, इनका कोई भी वहां पे हस्तक्षेप नहीं था when it comes to the operation, constitution, establishment of this. Nor did the government ever make any capital contribution towards setting it up. So when it was set it up, then also the government has not funded penny, no contribution, no capital contribution is been made by the central government. The majority, then again, coming to the members of this association, the majority of the members of the association are also having no relation with the government, are mostly private players. And when it comes to the board members or the members here, they have no relation with the government, no association with the government, and mostly they are private players. So this is how the situation looks to be, that it's an organization which is run on its own, no support, no establishment support, no capital support, nothing is being given by the government. Then can we call it a state? This is a question being posed here. Next is, it was discussed how the council that manages and oversees the affairs of the respondent association has no government interference and involvement except the nomination of just 3 members to its 30-member body. So कहता है, as such there is no interference from the government. Only thing that we have here is that out of these 30 members, which is part of this association, 30-member body, in that except this 20, 3 members, there is no member being nominated by the government. Only 3 members are being nominated by government. So can we say on the basis of this that it is a state within the meaning of Article 12? Next, it says that the employees are also governed by the Memorandum of Article of Association without any guidelines or statutory prescriptions being made by government in this regard. तो कहते हैं जो एम्प्लॉयज हैं इस पर्टिकुलर ऑर्गेनाइजेशन में उनके गवर्नेंस की बात की जाए वो कैसे गवर्न किए जाते हैं तो उसके अंदर भी हम देखते हैं that there is no as such guideline from the government. It is actually the memorandum of association or the article of association made by the organization itself. उसी से जो है एम्प्लॉयज जो है गवर्न किए जाते हैं. There is no prescription made by the government. The meeting and decision-making process of the association also do not involve any say of the government. जब डिसीजन मेकिंग बॉडी की बात आती है, मीटिंग्स की बात आती है, उसके अंदर भी गवर्नमेंट का किसी प्रकार का कोई भी से नहीं है. So we have seen as such there is no interference on the part of the government and no funding, no establishment, no rules regulation from the government. Then how can we say that it's a state within the meaning of Article 12? Thus, the court held that association was not functionally, neither no functional things operationally and administratively dominated by government control, rather enjoyed significant and substantive freedom or autonomy. So here it says that there is no functional support, no operational support, no administrative support given by the government here. So we can say that there is least control on the side of the government, no control being done by the government on this association. Rather, this particular organization is enjoying significant and substantive freedom or the autonomy. A lot of freedom or the autonomy has been given to the organization. It is running on its own, making its own rule, making rules for the employees. Everything has been managed by this organization itself. So how can we say that it will come under the definition of state? In view thereof, the court declined to interfere with the view taken by Bombay High Court that the Automotive Research Association of India was neither an agency nor instrumentality of the government, thus being not covered by Article 12 of the Constitution of India. And therefore, the Supreme Court here declines to interfere with the view taken by the Bombay High Court. The Bombay High Court ने कहा that it is not an agency or instrumentality of the government. ये सरकार की जो है इंस्ट्रूमेंट या फिर सरकार की तरफ से काम करने वाली ऑर्गेनाइजेशन नहीं है, ऐसा बॉम्बे हाई कोर्ट ने कहा था. इसके खिलाफ ये जजमेंट आया और यहाँ पे सुप्रीम कोर्ट ने भी उसके अंदर इंटरफेयर करने से डिक्लाइन कर दिया, कहा जो उनके द्वारा कहा गया है वो बिल्कुल सही है. So this is how this particular judgment this case has been dismissed by the Honorable Supreme Court, and the decision made by Bombay High Court was stand by. Then, if we try and conclude all this, the state is an entity against which one brings forward their claims and enforces the existing right. As we know that we bring our claims against the government, fundamental rights violation, then we file the cases against the state. And we know that state is defined in Article 12 of the Indian Constitution. It is an entity against which fundamental rights can be claimed. It may or may not be mentioned, but fundamental rights are positive and negative rights brought against the state. तो हम जानते हैं चाहे फंडामेंटल राइट जो है पॉजिटिव नेचर के हों चाहे वो नेगेटिव नेचर के हों, दे हैव ऑलवेज बीन ब्रॉट अगेंस्ट द स्टेट, हमेशा स्टेट के अगेंस्ट में ही लाए जाते हैं. The court has rightfully provided guidelines as to what must be taken into account, and there must be a holistic approach when one has to analyze the instrumentalities to understand if an entity comes under the definition of state or not. So the court यहाँ पे कहता है court has rightfully provided guidelines in the previous judgments. वहां साफ साफ ये बातें लिखी हैं कि कब कौन सी जो ऑर्गेनाइजेशन है वो गवर्नमेंट के डेफिनेशन के अंदर कवर की जाएगी. The court rightly held that one aspect or one feature or functions of an institution is supervised by or is under the direct or indirect control of the government. Furthermore, careful segregation between Article 12, non-Article 12 entities is essential to strike balance, and this judgment is rightly so. It provides effective guidelines as to what constitute an entity under Article 12 and what functions and criteria one should look for in order to ascertain the same. तो यहाँ पे कहता है after this judgment we have to see that we have to segregate the two, that what organizations will be considered under Article 12 and what organizations will be out of the purview when it comes to Article 12. So we have to strike a balance between the two. So this is how we understand this particular judgment, and this is how we understand the definition of state, and how we must pursue the state, and how we can go for the writ petitions, how to figure out whether this or that organization is a state or not will be is been clarified in this particular judgment. And again, another judgments also have been quoted here, which are of very landmark nature. So I hope you people have understood the concept of state, taking into consideration this particular judgment, which has been pronounced by the division bench of the Supreme Court, where the Supreme Court stand by the Bombay High Court's decision and dismisses the petition of the petitioner here. So thank you so much. Good night. Take care. Bye bye, everyone.